This is continuing coverage. The Black Swan murder trial of Ashley Benefield from the Hidden Killers podcast and True Crime Today. Now back to the courtroom.
All right, go ahead, sir. I've had a chance to review short.
Okay, so this was a DNA report, precisely what the circumstances are here. State initially wanted to introduce it, but then changed their mind because it didn't have any inculpatory conclusions for purposes of the defendant. At that point, the defense moved to introduce it because it was exculpatory. The court allowed the admissibility as a business record, distinguishing it from Crawford because since it was the defense that was seeking to admit it, the confrontation issue was not essential. And on appeal, the appellate court sustained that admission under the business record exception, which is precisely what the circumstances are here, Your Honor. So I can't imagine that the state is going to, and I would further say to the court, the chain of custody is irrelevant. We're not objecting to the chain of custody. I can't imagine that the state would object to their own chain of custody. So we think that the shorter case clearly establishes that the court can admit that DNA profile, the results, as a business record.
Judge, I thought I made it abundantly clear. I'm not objecting to it being a business record certification. That's what I said 6 times. My objection is that there has been no foundation laid to then make that report relevant. That is hearsay in the report. The fact that those swabs are identified to Ashley Benefield or Doug Benefield is hearsay to DNA labs. That means some crime scene tech who did not testify before this jury went and collected his DNA stain card. A different crime scene tech who testified she swabbed her but was not shown swabs to make sure those are the correct swabs, then swabbed her and put those in proper evidence. That's all. We don't have any evidence that the same swabs that she was collected then went to DNA labs. And that's what you have to lay the proper foundation. And this is the case I was referring to when I didn't refer to it by name, but this is what I read when I made my objections, because my objections are what I've already stated, but also 403, with just that lab report in evidence. This is very confusing. It's DNA, and it's overly prejudicial to this jury for what I think what it says is this state didn't argue, and I am arguing, how the forensic casework would be unfairly prejudicial or confusing in regards to the work of the jury. This is DNA. I don't know, they sent us the bench notes and the report, but there's no explanation of the statistics, how they came upon those statistics, where those swabs came from, all those things, and I think that will be very confusing to the jury without somebody here. So I'm not making a certified business records objection. I'm making an objection to the contents, and that there hasn't been an adequate foundation, and that there could be.
Sure. In rebuttal?
Yeah, so the court recalls that Detective Warren sent the swabs to the lab. Megan Dorvac testified that she swabbed Miss Benefield. I asked her why. She said because it would show who had touched her. The court should recall, consult your notes, Your Honor. Miss Benefield testified that Douglas Benefield grabbed her by the hand and spun her around as she tried to leave the house. This report corroborates that to the extent of, I think, 720,000 times, more likely. We think it's an essential component of our defense. Now, we don't have any. The chain of custody is irrelevant. Even though they've just basically undermined their own chain of custody, it's not an issue. It's the result that for our purposes and our defense is essential, Your Honor. This case allowed it to be admitted as a business record. The assistant has made eminently clear that that is not why she's challenging it as a business record. I don't seek to introduce the entire report. I will be quite happy reading these 2 sentences, if I may.
Thank you, because I haven't seen this.
Okay.
Thank you. All right, final thoughts? Is that everything?
Yes, sir.
This is, what I've been handed is not marked as an exhibit. It's a 5-page document from DNA Labs International. It actually It's a letter or report to Detective Justin Warren and a sergeant at the Manatee County Sheriff's Office, and it is signed by Jerome Rem, R-E-M-M, forensic DNA analyst. It lists a number of items, 14 different items that were apparently sent to DNA labs for DNA testing. And the particular section the defense says they want to admit is agency item number MRD5, which would correspond to DNA Labs International item 20-10880, swab from suspect's right hand. And it says that the testing was done, mixture of 2 individuals, at least 1 male contributor. And it says Doug Benefield and John Sant could not be ruled out as possible contributors to this foreign DNA profile. And it gives, based on its testing, 2 different propositions that were considered to explain the results. One is the DNA profile obtained from the swabs is 720,000 times more probable if the sample originated from Ashley Benefield, Doug Benefield, and 2 unknown persons than if it originated from Ashley Benefield and 3 unknown persons. So there's strong support that Ashley Benefield, Doug Benefield, and 2 unknown persons contributed to the profile rather than Ashley Benefield and 3 unknown persons. I am. I'm reading it as I go.
Okay, thank you, sir.
If applicable to the case, it is recommended that reference standards from any first-degree relatives of Doug Benefield be submitted for additional comparisons. And I think this is the second proposition that the DNA Labs is considering. The DNA lab profile obtained from the swabs is approximately 75 million times more probable if the sample originated from Ashley Benefield and 3 unknown persons than if it originated from Ashley Benefield, John Sant, and 2 unknown persons. Therefore, there is extremely strong support that Ashley Benefield and 3 unknown persons contributed to this DNA profile rather than Ashley Benefield, John Sant, and 2 unknown persons. The DNA profiles of additional contributors to the mixture were not determined. However, there's results that are suitable for comparison. All right, so obviously those of us who have done a number of these cases understand what those statistics mean when you're looking at known standards versus unknown DNA samples or swabs and the comparisons. I am not sure, and I do not have the belief that the interpretation of DNA results as outlined in this DNA Labs report is within the common knowledge of a lay juror, a regular juror. That's why the standard we usually see is one of the parties, whoever the proponent of the evidence is, calling the DNA analyst, generally after showing and evincing whoever took the sample, packaged it, where it was stored. It was then sent from the property and evidence room to the DNA lab. Then the DNA lab analyst will say how they went and got it, and I'm just going to disagree that chain of custody is not important. That's why we have it, and that's why we have certain predicates to establish evidence from a crime scene to court and who touched it and how it changed and what was done to it. So I disagree that that's not important.
Isn't that when the defense contests?
In the problem, well, I gave everybody the chance to argue.
Sorry.
So I got a chance to read the shorter case, and the shorter case supports what the court is saying. It says that they leave the issue for another day, whether it could qualify as a business record. However, there remains, and this is at 692 of the decision, however, there remains a very significant section 90.403 concern about the admissibility of a DNA forensic report if the expert preparing the report does not testify. And the reason the 4th DCA, it says so in the very next paragraph, the reason the 4th DCA upheld the admission was for that very reason, that the state did not argue 403. And here they are. Here the state has argued the 403 for a jury to understand what these mean, what these findings mean. I don't find that the probative value is, I do find the probative value is substantially outweighed by the danger of the confusion of the issues, the misleading of the jury to try and understand what this report says. And be subject to cross-examination from, well, this time it'd be the state, but it's usually the defense, to explain, where do you get this? How do you get 720,000 times? How many loci were matched? How did you conduct these evaluations? And then what does it mean, the very strong support? And then it's also, you've got, the other problem is, Mr. Taylor, you're telling me you only want to read this. You said two sentences. Yeah, these two sentences that are highlighted.
Correct.
But that's only one of the two sets of propositions that could potentially explain this. And the first proposition you want to use doesn't even mention Mr. Sant. And if I'm reading this correctly, there's also a recommendation that there should be some additional testing. There's also additional DNA profiles that are in these mixtures from Ms. Benefield's right hand that are suitable for comparison and have not been compared. So, I mean, I have significant concerns about the misleading of the jury by putting this in.
Can I make my
It would, if it would, so, no, sir. Based upon the request that's before me, which is only to put in and read into evidence these two sentences regarding one of the propositions that was considered by DNA labs and interpreting their test results, certainly that would be even more misleading because it doesn't get into the other proposition and the other testing that needs to be done. So based upon that, do you want to have this marked and put into evidence?
Yes.
As a proffer?
I'd like to proffer for the record, Your Honor.
Do you want to put a number on it? What's your next number?
29, but this is the whole record.
Well, hold on. You're handing me a stack of paper that's about, what, 1.5 inches tall?
Yes.
And the only thing you said you were going to enter was this 5-page.
Well, no, I said the only thing I wanted to was read those two sentences. This
But-
is full report.
All right. So it would be your intention to admit into evidence Defendant's Exhibit 29. Is this in here, or does this go in here?
Yeah, no, that I believe is in there. This comes back. Oh, I'm sorry, Your Honor, I stand corrected. This goes in court.
I'll let you put it where you want it.
Can I make a proffer for the record?
Yes, absolutely.
All right, thank you.
Oh, wait, beyond, I thought you already did. This is the proffer.
Well, I'd like to make a verbal proffer as to precisely why I think it should be admissible.
Yes, sir.
Okay, so unlike a DNA report that's inculpatory, which requires a chain of custody so that justice is established in the admission of inculpatory evidence, in this instance, Judge, we believe this DNA report is exculpatory, and we believe it's exculpatory because it confirms Ms. Benefield's testimony that Doug grabbed her by the hand and spun her around as she tried to flee. It's independent evidence that not only corroborates Ms. Benefield's testimony, but also corroborates our defense. And because it is exculpatory, chain of custody is irrelevant. We are making no objections to chain of custody. The case law that I submitted to the court, the shorter case, clearly would allow it. And it would be my intention, which I don't think is confusing at all to the jury, to tell them the DNA, reading from the report, the DNA profile obtained from the swabs is approximately 720,000 times more probable if the sample originated from Ashley Benefield, Douglas Benefield, and 2 unknown persons than if it originated from Ashley Benefield and 3 unknown persons. Now, maybe I misunderstand this, Your Honor, but to me what that says is there's 720,000 times more probable that Doug Benefield touched Ashley Benefield's hand. That's what I believe this says, and that's what I think we should be entitled to get to the jury.
Thank you. Do you want that right after the first page?
You can put it right on top, Your Honor.
It'll cover up the exhibit number then.
Oh, okay. Yeah,
So I'm just putting it right behind it. And as I said in my ruling, I think that those questions and what that means and how it's interpreted and how the jury can use that to be relevant to its deliberations and its findings. I'm not saying it's not relevant. I'm saying the problem is 403, as the 4th DCA recognized, not having that analyst causes significant 403 problems with confusion and misleading. So that's the basis of my ruling.
What if I told the court that the actual DNA lab expert is available, but not until after 2 tomorrow? And it would have to be by Zoom.
There's motions that Florida Rule of Criminal Procedure 3.116 defines how and when that can happen. So we need to bring the jury back in, and I just need to know if your intention is to call more witnesses or if you're resting.
Well, I make a formal request that the court debate the procedure so that we call the analysis. The court denies that.
Well, Florida Rule of Criminal Procedure 3.116 is very specific. It just came into effect, it was just substantially, I'll say substantially, amended effective July 1st of this year regarding the use of remote technology. If you want some time to look at that, I can certainly give you that.
I'm familiar with it.
So do you have a...
Rest.
Okay. Let me bring the jury in. I will, we can do that, then I can let them go for the evening. I'll tell them to be back tomorrow morning at 8:45, just like we've been doing with a 9 o'clock start.
Judge, just so you know also, it's or may recall request Cabo homicide or it's in our version of the I gave a copy of it, so I wonder if the court has it.
I will have to look. Did you send it by email?
No, I believe we handed it on.
Welcome back, everybody. Y'all can have a seat. All right, did anybody begin deliberations, talk with anybody outside the jury, or do any research?
No, sir.
All right, everybody says no. Mr. Taylor?
Yes, Your Honor, Ms. Benefield has no further witnesses, and we rest on her behalf.
All right, sir. Folks, at this point, it's 4:30. The attorneys and I have some work to do before we can get things going again in your realm of the case. So what I'm going to do is let you go for the evening. If you could please be back tomorrow morning at the jury assembly room around 8:45, just like today. There were probably people down there today. I don't think, was there any civil juries? There might be a smaller group tomorrow. There might be some judges in civil court picking some juries. So find your area and kind of hang out, and we'll have the deputies come down and get you as soon as we're ready and bring you up and get started.
Yes, sir.
All right, remember the rules for tonight? Don't talk amongst yourselves. Don't talk about the case with anybody else, and don't research about people, places, things, or legal topics.
Thank you.
Thank you. Have a good evening. You all can have a seat. All right, I'm going to have to give you all, let me give you guys a 5-minute break. I'm going to go upstairs, and I don't have it in the pile I have with me, but I have a whole other pile. So let me run upstairs and see if I can find.
I had it clipped.
Yeah, it was,
Yeah.
yes.
And I have the state's proposed jury instructions and the standard for self-defense because it changed in May, and I just wanted to include it in case we need to.
So you got the new one?
Yes.
All right.
But I brought the standard because the instructions are very different than they used to be, so I just brought an extra copy so we could go through it.
And you have an extra copy for?
Yes.
All right. So 5 minutes, I'll be right back down as soon as I check.
Thank you. Judge, can I come up?
Yes.
This is the.
You can have a seat, please.
I gave it to them, and this is the standard. I don't know if you need that, but I brought an extra copy. Okay, this is the state's proposed. If you have already a copy of ours, you can toss it because I made corrections. Okay.
And as we get started again, I was able to find the jury instructions the defense had handed up to me in the past, and I've had my judicial assistant run a copy and gave them back to the defense. And I think you had also given me this case, Gonzalez v. State.
The name alone?
Well, it looks like the handwriting that's been on a couple of your other documents, and so let me give it back to you, and it might jog your memory as to why you gave it to me.
Not my handwriting.
Oh, we'll wait. I didn't look over.
Yeah, so
Wait.
actually, I remember, I think Gonzalez was our consideration made about whether or not we had a charge self-defense based exclusively on the 9/11. They were a long way away from that.
All right. Do we just toss that? Or you keep it? Okay, sure.
It looks very similar to this.
Just trying to see if I have the right thing.
It did move.
Sorry, Madam Clerk. I was trying to hold it back.
I just wanted to see if I had the right packet.
Well, let me show you, let me show you what I gave to the judge.
But here, it looked like this is how
All right, so defense, do you have a copy of the state's proposed jury instructions?
Yes, sir.
And state, do you have a copy of the defendant's proposed?
I believe you.
And then I have mine that I did separately. If we could, I'd like to start with the state's version, and then when we get to an instruction defense that you have your own ideas or thoughts on, we'll see how we need to modify them or mesh them. So, Ms. Benefield, these jury instructions, as I've mentioned before, if I haven't, I will mention now, are very, very important. Too often, I think, people think of jury instructions kind of as an afterthought, but whenever we started this case, I had mentioned to the jury, and I say this several times, they listen to the testimony and receive evidence. They listen to the argument of counsel, and they listen to the instructions on the law by me. So this is 1/3 of what they are supposed to look at and consider. So the way that it works is, obviously, the defense has prepared some proposed jury instructions. I've got some that I've worked on, and the state has theirs. The reason I'm working from the states is that's just how we've always done it, at least in this circuit. It's generally the state prepares jury instructions. We kind of work off those. So as we go through, some of the things that I've mentioned in the past or have talked about or will talk about become much more clear when you really see the jury instructions and this is what the law is. So, Mr. Taylor, the way I do it is I'm going to, again, work from the state's version, which you have, and I'm going to call out the number. I won't read the whole thing, and just let me know in this first pass as we go through, do you have any objections, additions, corrections, or deletions to the standards? Then we can, after we go through that first pass, then we can get into some specifics.
Okay, and would that include omissions?
Yes, absolutely.
All right.
So for example, the first one is 3.1, Introduction to Final Instructions. Any objection to that?
No.
All right, so that's good. Looks standard. 3.2, Statement of the Charge. Any objection, correction, addition, deletions to that?
No.
All right, looks fine. Now, 7.1, Introduction to Homicide. That is one of the ones that you provided to me.
I think it's just the standard, Mr. Taylor, is it just the standard that provided, or is there a difference?
No, I provided in my packet that I work with, I provided the standard.
Okay, so there's no, I just wanted to see if there was a disagreement, because ours should be the standard as well.
So if you look at the
But mine was not edited.
understand, no, I see that. Yes, right. You just gave me, the actual printout that I look at from the Florida Supreme Court website. But so as you look at 7.1 as proposed by the state, do you have any objections to it?
The problem that I'm having with this is I haven't had time really to review this, so I can give the court an answer off the top of my head, but I don't know how I'm supposed to check for a misprint, a word that's been omitted.
I see what you're saying. This is why I call this my first pass. It's really a 30,000 foot
Okay.
overview. I mean, it's not uncommon right at the end. what you'll find is I have this thing about Oxford commas, and I think they need to be used. I don't understand not using them, but, so there's quite a few places where we're adding commas and so forth.
Yeah.
Please don't worry about those kind of details. I'm just talking in general. And this is one, quite frankly, we can skip if you prefer you want more time to take a look at it. That's absolutely fine.
No, with that explanation, then, no objection.
And I
Okay.
can tell you, it's standard other than we added the charge and then.
But if you see any typos or anything overnight.
Yeah.
All right, the next one is 7.4, murder in the second degree.
The yellow were things I didn't know if they were applicable, so it's just a reach or we didn't.
I think as I look at this overall, it looks like you've got just the standard in there. It looks okay. The issue is going to be if you all want that highlighted portion, if you want the sudden provocation. And I don't need a final answer now. It's highlighted, so you'll be able to let us know if you want that or don't want that.
Okay.
It's in there for now. Possession of a firearm and discharge causing death. 3.3D should just be the standard 1020 life instruction. All right, 3.3D looks right to me. And in fact, the one that I have from the defense, page 7 of 28,
Yep.
except for typeface, looks exactly the same. 3.4 lessers. So this is page 8 of 28 on the defense.
I believe that that's right statement as to the introduction to lesser.
You don't have to stand. If you want to, that's fine, but,
However, it's our position there should not be a lesser.
right, so are you prepared to make that argument now, or do you want to wait? It's up to you.
I think I can probably make it now, perhaps with the court giving me the consideration that if I think of something overnight, I might be able to solve it.
That's fine.
So we would cite the court to the Roberts decision, State of Florida versus Geraldo Roberts at 694 Southern 2nd 825, second ECA case. It was charge of attempted second-degree murder, aggravated assault, discharge of firearm from a vehicle, and carrying a concealed firearm. Reversed for the trial court's failure to give an instruction on attempted manslaughter and on definitions of justifiable and excusable homicide. But there is the statement made as follows. The trial court must instruct the jury completely on all necessarily include offenses, regardless of whether the facts of the case support the instruction. In this case, the trial court was required to give an instruction on attempted manslaughter and on the definitions of justifiable, excusable homicide. The trial court's failure to give the instructions is fundamental error and can be considered on appeal, even though defense counsel did not object. And then they cite Rinaldi versus State, also a second DCA decision, 614 Southern 2nd 1197. Parenthetical for what Rinaldi stands for is conviction for second-degree murder reversed because trial court's failure to include definition of justifiable homicide as part of manslaughter instruction, even though defendant failed to object. They say this then at that point. The only exception to this rule is if defense counsel affirmatively agrees to the omission or alteration of the instruction. So on behalf of Ashley Benefield, we request no lesser included offenses. We think this is an all or none deed. She is guilty of second degree murder or she's not guilty.
State, do you want to be heard?
Just that it's a category 1 lesser exemption.
For right now, I'm going to tentatively say leave it in, but again, you want to look at some stuff? No, I'm familiar with the case law. Yes, sir, I'm very aware of those. You wanted some more time to look and see if you could find anything, so
Yeah, if I
that's fine.
come up with anything else.
Leave it in for now, and as I look at manslaughter, it does look correct.
It appeared, the manslaughter instruction appears correct to me. However, I'm just not sure about the applicability of the various subsections at this point.
All right, and then 3.3A, the next page is the aggravation for the, I'm sorry, did you say give you a minute?
Yeah.
Oh, yeah, of course.
Yeah, no, I think it's,
Oh, all right, yeah, 3.3A looks like the standard. All right, justifiable use of deadly force.
Excuse me, I don't think we got that far when I was fixing it.
I'm looking across 3 different pages here. Yes. All right, so here's, are you on 3.6F?
Yep.
All right, so here's going to become the first issue. Right about the middle of the page, Ashley Benefield was justified in using deadly force if she reasonably believed that such force was necessary to prevent, of course we know there's two. I'm sure you want A, imminent death or great bodily harm to herself.
Yeah.
Are you also asking for an instruction on the forcible felony?
Absolutely.
And I saw that towards the end of your paperwork. And it looks like you're asking for, you see that state towards the back of their packet? Looks like you're asking for burglary, felony bat, ag bat, ag assault, false imprisonment. That looks like all of them.
Burglary.
Yes, yeah, I started with that one. I actually went from back to front, so
Oh, okay.
burglary, felony bat, ag assault, and false imprisonment.
I believe that's correct.
Misunderstanding. For all of those felonies?
Well, I think that's your starting point.
Yes.
All right, State, let's start off easy and ask, are there any of those forcible felonies that you agree with the court instructing the jury?
Before we get there, Judge, on the standard I gave you, you read the sentence right before this paragraph. And it says the law on justifiable use of deadly force as follows. And then it says, give if the defendant is relying on 776.012 or 776.0312, but not relying on 760.131. So it seems like now you're supposed to pick, because it is repetitive, because that same language is in each section.
All right, 776.012.2. It appears, I would say, that the defense is relying on 776.012 subsection 2. That's the self-defensive person.
It's the second part of that sentence. It says, but not relying on 776.01 and 013. And I believe they are relying on 7.01.
All right, that's protection in the home.
More continuing coverage is on the way. The Black Swan murder trial of Ashley Benefield from the Hidden Killers podcast and True Crime Today. Press subscribe now.